Chain of custody. In People versus Gary de la Cruz, GR 205-821, October 1st, 2014, the Supreme Court said that compliance with the chain of custody requirement ensures the integrity of confiscated, seized, and/or surrendered drugs and/or drug paraphernalia in four respects, namely: A. The nature of the substances or items seized. B. The quantity of the substances or items seized. C. The relation of the substances or items seized to the incident allegedly causing their seizure. And D. The relation of the substances or items seized to the person or persons alleged to have been in possession of or peddling them. Compliance with the chain of custody requirement forecloses opportunities for planting, contaminating, or tampering of evidence in any manner. In People versus Viterbo, cited in People versus Charlie Serene, 2015, the Supreme Court said that the prosecution must be able to account for each link in the chain of custody over the dangerous drug, from the moment it was seized from the accused up to the time it was presented in court as proof of the corpus delicti. Thus, in People versus Butial, 2015, where PO2 Martinez admitted that he did not put any markings on the two plastic sachets handed to him by Lagdan after the latter's purchase of the same from the accused in a buy-bust operation. The court held that there was failure to comply with the chain of custody requirements and the accused must be acquitted. Marking after seizure is the starting point in the custodial chain. Thus, it is vital that the seized contraband be immediately marked because succeeding handlers of the specimen will use the marking as reference XXX. The absence of the markings creates an uncertainty XXX, and the lack of certainty on a crucial element of the crime warrants the reversal of the judgment of conviction. When an offense had just been committed and there is probable cause to believe, based on his personal knowledge of facts or of other circumstances, that the person to be arrested has committed the offense. Under this paragraph, two stringent requirements must be complied with, namely, an offense had just been committed, and B, the person making the arrest has probable cause to believe, based on his personal knowledge of facts or of other circumstances, that the person to be arrested had committed it. Hence, there must be a large measure of immediacy between the time the offense is committed and the time of the arrest. And if there was an appreciable lapse of time between the arrest and the commission of the crime, a warrant of arrest must be secured. Aside from the sense of immediacy, it is also mandatory that the person making the arrest has personal knowledge of certain facts indicating that the person to be taken into custody has committed the crime. No valid arrest in People versus Del Rosario, 1999. It was held that these requirements were not complied with. The arrest came a day after the offense was committed, and thus the offense had not been just committed. Furthermore, the arresting officer had no personal knowledge of facts indicating that the person to be arrested had committed the offense, since they were not present and were not actual eyewitnesses to the crime, and they became aware of the identity of the driver of the getaway tricycle only during the custodial investigation. The same conclusion was reached in People versus Samus, September 17, 2002. Inasmuch as the killing was not done in the presence of the arresting officer, and the incident took place 8 days before the warrantless arrest. In Go versus Court of Appeals, 6 days after the shooting, as the petitioner presented himself before the San Juan police station to verify news report that he was being hunted, the police detained him because an eyewitness had positively identified him as the gunman who shot Magwan. The court held that there was no valid arrest. It cannot be considered as within the meaning of the offense had just been committed, inasmuch as 6 days had already elapsed. Neither did the policeman have personal knowledge of the facts that Go shot Magwan. In People versus Olivares, it was held that the warrantless arrest of the accused 2 days after the discovery of the crime was unlawful. In People versus Kimura, The warrantless arrest of the accused for selling marijuana 2 days after he escaped was held invalid. Similarly, in San Agustin versus People, the warrantless arrest of the barangay chairman for illegal detention 7 days after he locked up somebody was declared illegal. In People versus Kubukubin, it was held that the policeman, not having personal knowledge of facts indicating that the accused committed the crime, the arrest was invalid. In People versus Pensil, it was held that there was no probable cause to justify the warrantless arrest considering the following circumstances. The arresting team was only armed with the knowledge of the suspect's attire, which the prosecution witness admitted during the trial he could not remember. The team did not have a physical description of the suspect nor his name. The team was not given a specific place to search as only a vicinity of the Muslim area in Quiapo was given. And the team zeroed in on the accused who were eating halo-halo, which is not a crime in itself. The bulging waistline, in light of prevailing circumstances, is insufficient to constitute probable cause for the arrest of the accused. Valid arrest. In People versus Guerrente, where the policemen saw the victim dead at the hospital, and when they inspected the crime scene, they found the instruments of death, and the eyewitnesses reported the happening and pointed to Guerrente as soon as the killers. The warrantless arrest of Guerrente only 3 hours after the killing was held valid. Since the policemen had personal knowledge of the violent death of the victim and of the facts indicating that Guerrente and two others had killed the victim. Further, the search of Guerrente's persons and the seizure of the marijuana leaves were valid as an incident to a lawful arrest. Thus, in Robin Padilla versus Court of Appeals, the court held that there was a valid arrest, as there was neither supervening event nor a considerable lapse of time between the hit and run and the apprehension. After the policemen had stationed themselves at possible exits, they saw the fast approaching vehicle, its plate number, and the dented hood and railings thereof. These formed part of the arresting officer's personal knowledge of the fact that Padilla's vehicle was the one involved in the incident. In Joey Pestillos versus Moreno Generoso, the police officers arrived at the scene of the crime less than 1 hour after the alleged mauling. They found Attorney Generoso wounded. Attorney Generoso positively identified the petitioners as those responsible. Petitioners and Attorney Generoso lived in the same neighborhood, and when the petitioners were confronted by the arresting officers, they did not deny their participation. Although they had narrated a different version, the police officers had personal knowledge of facts or circumstances justifying the arrest, circumstances which were well within the police officers' observation, perception, and evaluation at the time of the arrest. Likewise, in People versus Abriol, it was held that the warrantless arrest was valid. It was made after the fatal shooting and pursuit of a fast-moving vehicle seeking to elude pursuing police officers, and a more than reasonable belief on the part of the police officers that the fleeing suspects aboard the motor vehicle had just engaged in a criminal activity. In Cadua versus Court of Appeals, the Supreme Court, quoting Ricardo Francisco, Criminal Procedures 2nd edition 1994, page 207-208, said that it has been ruled that personal knowledge of facts in arrests without a warrant must be based on probable cause, which means an actual belief or reasonable grounds of suspicion. Peace officers may pursue an arrest without warrant any person found in suspicious places or under suspicious circumstances, reasonably tending to show that such person has committed or is about to commit any crime or breach of the peace. Probable cause for an arrest without warrant is such a reasonable ground of suspicion supported by circumstances sufficiently strong in themselves to warrant a reasonable man in believing the accused to be guilty. This was reiterated in People versus Escordial, where the Supreme Court added that the reasonable suspicion must be founded on probable cause, coupled with good faith on the part of the peace officer making the arrest. In Kadua, the Supreme Court held that the arrest without warrant was valid. The fact that the robbery case was never brought to trial does not mean that the legality of the arrest was tainted, for such arrest does not depend upon the indubitable existence of the crime. The legality of apprehending the accused would not depend on the actual commission of the crime, but upon the nature of the deed, where from such characterization it may reasonably be inferred by the officer or functionary to whom the law at the moment leaves the decision for the urgent purpose of suspending the liberty of the citizen. When the attempted arrest does not fall under any of the cases provided in Rule 113, Section 5, Rules of Criminal Procedure, for warrantless arrests, the NBI agents could not, regardless of their suspicion, authorize the arrest of the students without a warrant or even effect the arrest themselves because only the courts could decide the question of probable cause. Posadas versus Ombudsman. When the person to be arrested is a prisoner who has escaped from a penal institution or a place where he is serving final judgment or temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. When the right is voluntarily waived, then the illegality of the arrest may no longer be invoked to affect the release of the person arrested. Appellant is stopped from questioning the illegality of his arrest when he voluntarily submitted himself to the jurisdiction of the court by entering a plea of not guilty and by participating in the trial. People versus Salvatierra, People versus De Guzman, People versus Lopez, People versus Tirula, and People versus Navarro. It is necessary, therefore, that the petitioner should question the validity of the arrest before he enters his plea. Failure to do so would constitute a waiver of his right against unlawful restraint of his liberty. People versus Conanan and People versus Peña, Florida. Note, however, that the waiver is limited to the illegal arrest. It does not extend to the search made as an incident thereto, or to the subsequent seizure of evidence allegedly found during the search. Thus, when the arrest is incipiently illegal, even if the right to question the same is deemed waived by the accused entering his plea, it follows that the subsequent search is similarly illegal. Any evidence obtained in violation of the Constitution provision is legally inadmissible in evidence under the exclusionary rule. People versus Peralta. In a number of cases, the Supreme Court held that the posting of a bail bond constituted a waiver of any irregularity attending the arrest. Calanta versus Villanueva, People versus Dural, Bagcal versus Villarasa, Cojuanco versus Sandigan Bayan. Section 26, Rule 114, Revised Rules in Criminal Procedure. An application for or admission to bail shall not bar the accused from challenging the validity of his arrest, provided that he raises the challenge before entering his plea. The consequent filing of charges and the issuance of a warrant of arrest against a person invalidly detained will cure the defect of such detention, or at least deny him the right to be released. Francisco Juan Laranaga versus Court of Appeals. Warrantless searches. When the right is voluntarily waived. For the valid waiver of a constitutional right, it must appear first that the right exists. Secondly, that the person involved had knowledge, either actual or constructive, of the existence of such right. And thirdly, that the said person had an actual intention to relinquish the right. B. Garcia versus Loxin. The consent must be voluntary, that is, unequivocal, specific, and intelligently given, uncontaminated by any duress or coercion. Hence, consent to a search is not to be lightly inferred, but must be shown by clear and convincing evidence. Whether consent to a search was in fact voluntary is a question of fact to be determined from the totality of all the circumstances, the age of the defendant, whether he was in a public or secluded location, whether he objected to the search or passively looked on, the education and intelligence of the defendant, the presence of coercive police procedure, the defendant's belief that no incriminating evidence will be found, the nature of police questioning, the environment in which the questioning took place, and the possible vulnerable subjective state of the person consenting. It is the state that has the burden of proving by clear and convincing evidence that the necessary consent was obtained and that it was voluntarily and freely given. Cabales versus Court of Appeals. Some cases showing valid waiver. In People versus Umawing, the accused driving a vehicle was stopped at a checkpoint, and when the vehicle was inspected, the soldiers asked permission to see the contents of a bag which was partially covered by a spare tire. The accused consented, and upon inspection, the bag was found to be full or have contained marijuana. In People versus La Serna, September 5, the occupants of the taxicab readily consented when the policemen sought permission to search the vehicle. In People versus Korea, where police officers informed that the accused would deliver marijuana, followed the accused, then later accosted him, and one of the policemen opened a tin can in the jeepney of the accused, but the accused did not protest. The Supreme Court held that there was consent. In People versus Quizon, the accused gave written consent for the NBI agents to search his bags. In People versus Exala, the right was deemed waived because the accused did not object to the admissibility of the evidence during the trial, and the submissive stance after the discovery of the bag, and the absence of any protest, which thus confirmed their acquiescence. In People versus Ramos, the Supreme Court said that the evidence for the prosecution clearly disclosed that Ramos voluntarily allowed himself to be frisked and that he gave the gun voluntarily to the police. Thus, there was deemed a valid waiver. Searches of passengers at airports. Section 9 RA 6235 provides every ticket issued to a passenger by the airline or air carrier concerned shall contain, among others, the following condition printed thereon. Holder hereof and his hand-carried luggages are subject to search for and seizure of prohibited materials or substances. Holders refusing to be searched shall not be allowed to board the aircraft, which shall constitute a part of the contract between the passenger and the air carrier. In People versus Gatward, February 7, 1997, it was held that when the accused checked in his luggage as a passenger of a plane, he agreed to the inspection of his luggage in accordance with customs laws and regulation, and thus waived any objection to a warrantless search. In People versus Susan Canton, it was held that a search made pursuant to routine airport security procedure is allowed under RA 6235, which provides that every airline ticket shall contain a condition that hand-carried luggage, etc., shall be subject to search, and these conditions shall form part of the contract between the passenger and the air carrier. To limit the action of the airport security personnel to simply refusing the passenger entry into the aircraft and sending her home as suggested by the appellant, and thereby depriving the security personnel of the ability and facility to act accordingly, including to further search without warrant in light of such circumstances would be to sanction impotence and ineffectiveness in law enforcement to the detriment of society. Thus, in this case, the strip search in the ladies' room was justified under the circumstances. In People versus Johnson, the Supreme Court upheld the validity of searches conducted on passengers attempting to board an aircraft whose carry-on baggage as well as checked-in luggage are subjected to X-ray scans, and passengers themselves are made to pass through metal detectors. Given the minimal intrusiveness, the gravity of the safety interests involved, and the reduced privacy expectations associated with airline travel, these searches are reasonable. In People versus Suzuki, the Supreme Court held that PASCOM agents have the right under the law to conduct searches for prohibited materials or substances at the airport, and to effect the arrest of those found to be carrying such prohibited materials. to simply refuse passengers carrying suspected illegal items to enter the pre-departure area, as claimed by the appellant, is to deprive the authorities of their duty to conduct search, thus sanctioning impotence and ineffectiveness of the law enforcers to the detriment of society. No waiver. In People versus Barros, the silence of the accused was not construed as consent. Rather, it was a demonstration of regard for the supremacy of the law. In this case, the warrantless search was declared invalid because there was no showing of any circumstances which constituted probable cause for the peace officer to search the carton. Neither did the peace officer receive any information or tip off from an enforcer, nor did they contend that they detected the odor of dried marijuana. In Anyag versus Comelec, the Supreme Court said that, in the face of 14 armed policemen conducting the operation, driver Aureliano, being alone and a mere employee of the petitioner, could not have marshaled the strength and the courage to protest against the extensive search conducted on the vehicle. Consent given under intimidating or coercive circumstances is not consent within the purview of the constitutional guarantee. In People versus Tudtud, the Supreme Court said that acquiescence in the loss of fundamental rights is not to be presumed. Acquiescence. Sorry. The fact that a person failed to object to a search does not amount to permission thereto. In any case, any presumption in favor of regularity would be severely diminished by the allegation of appellants that the arresting officers pointed a gun at them before asking them to open the subject box. Appellants' implied acquiescence, if at all, could not have been more than mere passive conformity given under coercive or intimidating circumstances, and thus is considered no consent at all within the purview of the constitutional guarantee. Consequently, appellant's lack of objection to the search and seizure is not tantamount to a waiver of his constitutional rights or a voluntary submission to the warrantless search and seizure. In People versus Victor Cogaed, the Supreme Court ruled the accused did not waive his constitutional right when he allowed the police officer to search his bags. The implied acquiescence to the search, if there was any, could not have been more than passive conformity given under intimidating or coercive circumstances, and is thus considered no consent at all within the purview of the constitutional guarantee. Cogaed's silence or lack of aggressive objection was a natural reaction to a coercive environment brought about by the police officer's excessive intrusion into his private space. In Louis versus Matilano, while admittedly Paulina Matilano failed to object to the opening of her wooden closet and the taking of their personal properties, such failure to object or resist did not amount to an implied waiver of her right against the unreasonable search and seizure. The petitioners were armed with handguns. Petitioner Louis had threatened and intimidated her, and her husband was out of the house when the petitioner and his cohorts conducted the search. Waiver by implication cannot be presumed. There must be a clear and convincing evidence of an actual intention to relinquish the right in order that there may be a valid waiver. Waiver must be given by the person whose right is violated. In People versus Damaso, PC officers sent to verify the presence of CPP or NPA members in the Gupan city reached the house suspected to be rented by a rebel. Outside the house, they saw one Luz Tankianko, who turned out to be a helper of the accused. The PC officer told Luz that they already know that she was a member of the NPA and requested that they be allowed to look around. Luz consented. Inside the house, the team found subversive materials and 5 firearms, which Luz identified as belonging to the accused. The court held that the constitutional right against unreasonable searches and seizures, being a personal one, cannot be waived by anyone except the person whose rights are invaded, or one who is authorized to do so in his behalf. Hence, there was no evidence that Luz was authorized to open the house of the accused in his absence. Accordingly, the search as well as the seizure was declared illegal. But in Jose Lopez versus Commissioner of Custom, there was deemed a valid waiver, where upon a warrantless search of a hotel room, consent and voluntary surrender of papers belonging to the registered but absent occupant was given by a woman identified as the wife of the occupant, although it turned out later that she was in fact a mere manicurist. This ruling was not applied in People versus Assis, because at the time the blood-stained pair of shorts was recovered. Appellant Formento, together with his wife and mother, was present. Being the subject of the search, he himself should have given consent. Added to this is the fact that the appellant is a deaf mute who could not understand what was happening at the moment, there being no interpreter to assist him. His seeming acquiescence to the search without a warrant may be attributed to plain and simple confusion and ignorance. Scope of the waiver. In Viroy versus Layage, it was held that where permission to enter the residence is given to search for rebels, it is illegal to search the rooms therein and seize firearms without a search warrant, when there is valid reason to stop and frisk. Stop and frisk searches are necessary for law enforcement. That is, law enforcers should be given the legal arsenal to prevent the commission of offenses. However, this should be balanced with the need to protect the privacy of citizens. The balance lies in the concept of suspiciousness present in the situation where the police officer finds himself. A basic criterion would be that the police officer, with his or her personal knowledge, must observe the facts leading to the suspicion of an illicit act. It is the police officer who should observe facts that would lead to a reasonable degree of suspicion of a person. The police officer should not adopt the suspicion initiated by another person. This is necessary to justify the person suspected be stopped and reasonably searched. Anything less than this would be an infringement upon one's basic right to security of one's persons and effect. People versus Kugaid. In Manalili versus Court of Appeals, the Supreme Court upheld the validity of the search of as akin to stop and frisk, which, in the landmark U.S. case of Terry versus Ohio, was defined as the vernacular designation of the right of a police officer to stop a citizen on the street, interrogate him, and pat him for weapons whenever he observes unusual conduct, which leads him to conclude that criminal activity may be afoot. In this case, the policeman chanced upon the accused who had reddish eyes, walking in a swaying manner, and who appeared to be high on drugs, thus the search. In People versus Sichua, the Supreme Court said that for a stop and frisk situation, the police officer should properly introduce himself and make initial inquiries, approach and restrain a person who manifests unusual and suspicious conduct in order to check the latter's outer clothing for possibly concealed weapons. The apprehending police officer must have a genuine reason, in accordance with the police officer's experience and the surrounding conditions, to warrant the belief that the person to be held has weapons or contraband concealed about him. It should, therefore, be emphasized that a search and seizure should precede the arrest for the principle to apply. Thus, in People versus Solayao, the Supreme Court found justifiable reason to apply the stop and frisk rule because of the drunken actuations of the accused and his companions, and because of the fact that his companions fled when they saw the policeman. And finally, because the peace officer were precisely on an intelligence mission to verify reports that armed persons were roaming the vicinity. But the rule was not applied in Malacat versus Court of Appeals, where police officers conducting a patrol on the strength of an information that a Muslim group would explode a grenade saw petitioner and companions attempting to explode a grenade, but who, upon seeing the policeman, desisted and ran away. Then 2 days later, police officers saw petitioner at a street corner, accosted him when his companions ran away, and then searched him and found a grenade. In this case, the Supreme Court said that there was no valid search because there was nothing in the behavior or conduct of the petitioner which could have elicited even mere suspicion other than that his eyes were moving fast. There was no reasonable ground to believe that the petitioner was armed with a deadly weapon, where the search and seizure is an incident to lawful arrest. Section 12, Rule 126, as clarified in the 1985 Revised Rules on Criminal Procedure, provides that a person lawfully arrested may be searched for dangerous weapons or anything which may be used as proof of the commission of an offense without a search warrant. A person lawfully arrested may be searched for dangerous weapons or anything which may be used as proof of the commission of an offense without a search warrant. The purpose of allowing a warrantless search and seizure as an incident to a lawful arrest is to protect the arresting officer from being harmed by the person arrested who might be armed with a concealed weapon, and to prevent the latter from destroying evidence within reach. It is therefore a reasonable exercise of the state's police power to protect law enforcers from injury that may be inflicted on them by a person they have lawfully arrested, and two, evidence from being destroyed by the person arrested. People versus Kalanshao. In People versus Estella, the Supreme Court said that the prevailing rule is that the arresting officer may take from the arrested individual any money or property found upon the latter's person, that which was used in the commission of the crime or was the fruit of the crime, or which may provide the person arrested with a means of committing violence or escaping, or which may be used in evidence in trial of the case. The search must, however, be contemporaneous to the arrest and made within a permissible area of search. In People versus Greg Buenaventura, the Supreme Court said that in a bypass operation, the police officers conducting the operating are not only authorized but duly bound to apprehend the violator and to search him for anything that may have been part of or used in the commission of the crime. As a rule, the arrest must precede the search. The process cannot be reversed. Nevertheless, a search substantially contemporaneous with an arrest can precede the arrest if the police have probable cause to make the arrest at the outset of the search. People versus Nuevas. As a rule, let me repeat this. The arrest must precede the search. The process cannot be reversed. Nevertheless, a search substantially contemporaneous with an arrest can precede the arrest if the police have probable cause to make the arrest at the outset of the search. People versus Nuevas. In order that a valid search may be made as an incident to a lawful arrest, it is necessary that the apprehending officer must have been spurred by probable cause in effecting the arrest, which could be considered as one in cadence with the instance of permissible arrests enumerated in Section 5, letter A of Rule 113 of the Rules of Court. In this case, the officers could reasonably assume, since the informant was by their side and had so informed them and pointed out the culprit, that the drugs were in the appellant's luggage and it would have been responsible, if not downright absurd, for them to adopt a wait-and-see attitude at the risk of eventually losing their quarry. People versus Montilla. Some cases illustrating the principle. In People versus De La Cruz, the Supreme Court said that while it may be conceded that in a bypass operation there is seizure of evidence from one's person without a search warrant, nonetheless, because the search is an incident to a lawful arrest, there is no necessity for a search warrant. Similarly, in People versus Calubiran, where the accused arrested in a bypass operation was frisked by the operatives who found marked money which was used to buy 2 sticks of marijuana cigarettes and 17 more marijuana cigarettes. The search was deemed valid as an incident to a lawful arrest. In People versus Musa, it was held that a bypass operation, the law enforcement agents may seize the marked money found in the person of the pusher immediately after the arrest, even without a search warrant. However, in People versus Zapanta, where as an incident to a bypass entrapment operation, a raid of the house of the accused was conducted and one marijuana stick was found under the mat. The Supreme Court said that apart from the uncertainty among the witnesses as to how many marijuana cigarettes, if any, were found in Sapanta's possession during the raid, search was made without a warrant. Therefore, the marijuana cigarettes seized in the raid were inadmissible in evidence. In People versus Luisito, where the police saw a gun plainly visible tucked in appellant's waist and appellant could not show any license for the firearm, the warrantless arrest was held valid, and consequently, the discovery of drug paraphernalia and shabu in appellant's car, as well as the seizure of the same, was justified. However, in People versus Aruta, the court invalidated the search and seizure made on a woman, Aling Rose, who upon alighting from a bus was pointed out to be the informant. Was pointed out by the informant. The Supreme Court declared that in a search and seizure as an incident to a lawful arrest, it is necessary for probable cause to be present, and probable cause must be based on reasonable ground of suspicion or belief that a crime has been committed or is about to be committed. In this case, the accused was merely crossing the street and was not acting in any manner which would engender a reasonable ground to believe that she was committing or about to commit a crime. Note that in this case, there was the additional fact that the identity of the accused had been priorly ascertained and the police officer had reasonable time within which to obtain a search warrant. The presence of these circumstances distinguishes this case from People versus Malmsted, Malmstedt, GR 911107. I don't know how to pronounce that. Cases where arrest was declared valid without necessarily being preceded by an arrest. In People versus Sucro, the Supreme Court held a warrantless search and seizure can be made without necessarily being preceded by an arrest without that the said search is effected on the basis of probable cause. Again, in People versus Sucro, the Supreme Court held that a warrantless search and seizure can be made without necessarily being preceded by an arrest, provided that the said search is effected on the basis of probable cause. In People versus Valdez, the arrest of the accused and the subsequent search and seizure of the marijuana by SPO Mariano was held valid on the basis of probable cause. Mariano had probable cause to stop and search the buses coming from Banaue in view of the information he got from the civilian asset that somebody having the same appearance as the accused and with a green bag would be transporting marijuana. In Posadas versus Court of Appeals, the court upheld the validity of a search made by police officer on one who confronted by the police because he was acting suspiciously, ran away, although in People versus Rodriguez, the arrest and consequent search of the accused simply because he was acting suspiciously was held invalid. In People versus Tangliben, where two policemen on the surveillance after receiving a tip from an informer noticed a person carrying a red bag acting suspiciously, then confronted the person and found inside bag marijuana leaves. The Supreme Court held that the seizure was valid as an incident to a lawful arrest. The court said that the matter presented urgency when the informer pointed to the accused as the one who was carrying marijuana. The police officer faced with such on-the-spot information had to act quickly. There was not enough time to secure a search warrant. In People versus Malmsted, June 19, 1991, where soldiers manning a checkpoint set up because of persistent reports that vehicles were transporting marijuana and other prohibited drugs noticed a bulge in the accused's waist, and the pouch bag was found to contain hashish, and search was deemed valid as an incident to a lawful arrest, as the accused was then transporting prohibited drugs. and there was sufficient probable cause for the said officers to believe that the accused was then and there committing a crime. However, in People versus Chua Hosan, the Supreme Court said that while a contemporaneous search of a person arrested may be effected for dangerous weapons or proofs or implements used in the commission of the crime, and which search may extend to the area within his immediate control, where he might gain possession of a weapon or evidence he can destroy, a valid arrest must precede a search. A valid arrest must precede a search. The process cannot be reversed. In this case, there was no valid arrest that could justify the search because none of the telltale clues, example, a bag or a package emanating the odor of marijuana or other prohibited drugs. People versus Claudio. People versus Lacerna. Or a confidential report and or positive identification by informers of couriers of prohibited drugs and or the time and place where they transport the same. People versus Lo Ho Wing. A suspicious demeanor or behavior. People versus Tangliban. Or a suspicious bulge in the waist. People versus Malms Ted. Accepted by this court as sufficient to justify warrantless arrest. There was no classified information that a foreigner would disembark at Tamokalau Beach bearing prohibited drugs on the date in question. The fact that the vessel that ferried him to shore bore no resemblance to the fishing vessels in the area did not automatically mark him as in the process of perpetrating an offense. Permissible area of search. The warrantless search and seizure as an incident to a lawful arrest may extend beyond the person of the one arrested to include the premises or surroundings under his immediate control. People versus Hindoy. Thus, in People versus Cuenco, where the accused was arrested in a bypass operation while standing by the door of the store, which was part of the house, it was proper for the police officer to search the house of the accused, the same being in the area within his immediate control. In the office of the court administrator versus Baron, where the judge was caught in flagrante as he was placing the bundles of money under the driver's seat of his car, and the money was seized by the NBA agents, it was held that there was no need for a warrant to seize the fruits of the offense, the seizure being incidental to a lawful arrest. The same rule was applied in People versus Catan, where a bypass operation was made at the house of the accused, and immediately after the purchase, the accused was arrested and a search made of the premises. Where the accused was first and arrested in the street for possession of 2 cellophane bags of marijuana, and when asked if he had more, answered that he had more marijuana at his house. The search conducted by the police officers in the house and the consequent seizure of 10 cellophane bags of marijuana was held invalid because the house was no longer within the reach and control of the accused. Espano versus Court of Appeals. Likewise, in People versus Che Chun Ting, where the accused was outside the apartment unit and in the act of delivering to the poster buyer the bag of shabu, and the apartment unit was not even his residence but that of his girlfriend, the inside of the apartment unit was no longer a permissible area of search, as it could not be said to be within his reach and immediate control. The warrantless search therein was therefore unlawful. In People versus Kubin, the gun seized was within the area of immediate control of the accused. The same could not have been validly seized as an incident to a lawful arrest. I'm sorry, what? In People versus Kubin, it was held that since neither the t-shirt nor the gun seized was within the area of immediate control of the accused, the same could not have been validly seized as an incident of a lawful arrest. Seizure of allegedly pornographic materials, PD 969, mandates the forfeiture and destruction of pornographic materials involved in the violation of Article 21 of the Revised Penal Code, even if the accused was acquitted. Frederick Nogales. But in Peter versus Court of Appeals, it was held that the respondents had not shown the required proof to justify a ban and to warrant confiscation of the magazines they were not possessed of a lawful court order, finding the materials to be pornographic, and B. authorizing them to carry out a search in seizure. To justify a warrantless search as an incident to a lawful arrest, the arrest must be on account of a crime having been committed. Here, no party has been charged, neither is any charge being pressed against any party. The Supreme Court outlined the procedure to be followed. Thus, a criminal charge must be brought against the persons for purveying the pornographic materials, an application for a search and seizure warrant obtained from the judge, who shall determine the existence of probable cause before issuing such warrant, the materials confiscated brought to the court in the prosecution of the accused for the crime charge. The court will determine whether the confiscated items are really pornographic, and the judgment of acquittal or conviction rendered by the court accordingly. Search of vessels and aircrafts. A search warrant may readily be obtained when the search is made in a store, dwelling house, or other immobile structure. But it is impracticable to obtain a warrant where the search is conducted on a mobile ship or an aircraft or other motor vehicles, since they can quickly be moved out of the locality or jurisdiction where the warrant must be sought. People versus Billion Macarius. A fishing vessel found to be violating fishery laws may be seized without a warrant on two grounds. Firstly, because they are usually equipped with powerful motors that enable them to elude pursuit, and secondly, because the seizure would be an incident to a lawful arrest. Roldan versus Ottaka. Thus, in Hisen versus Court of Appeals, the court upheld the warrantless search of a fishing boat made by the police on the strength of a report submitted by Task Force Bantay Dagat. In People versus Aminuddin, where the accused was searched and arrested upon disembarkation from a passenger vessel, the court held that there was no urgency to effect a warrantless search, as it is clear that the Philippine Constabulary had at least 2 days from the time they received the tip until the arrival of the vessel, within which they could have obtained a warrant to search and arrest the accused. Yet they did nothing. No effort was made to comply with the law. A similar ruling was made in People versus Ensenada, when a search and seizure was made of a passenger who disembarked from MV Sweet Pearl. The court noted that since the informer's tip was received at 4 p.m. on the day before the arrival of the vessel, the authorities had ample time to obtain a search warrant. The Tangliban ruling cannot apply because the evidence did not show that the accused was acting suspiciously when he disembarked from the vessel. The situation in People versus Saigon is different because the NARCOM agents received the tip in the early morning of July 8, 1992, and the boat on which the accused boarded was due to arrive at 6 a.m. on the same day. Furthermore, there was probable cause consisting of two parts. Firstly, the agents conducted a bypass operation, and secondly, they received confidential information that the boat was due to leave soon. Similarly, in People versus Ayangao, the informant arrived at the police station at 5 a.m. on August 13, 1999, and informed the officers that the appellant would be arriving at 6 o'clock a.m. that day. The circumstances clearly called for an immediate response from the officers. Search of moving vehicles. A warrantless search of a moving vehicle is justified on the ground that it's not practicable to secure a warrant because the vehicle can be moved quickly out of the locality or jurisdiction in which the warrant may be sought. Searches without warrant of automobiles are also allowed for the purpose of preventing violations of smuggling or immigration laws, provided that such searches are made at borders or constructive borders, like checkpoints near the boundary lines of the state. One such form of search is the stop and search without a warrant at military or police checkpoints, which has been declared not to be illegal per se, so long as it is required by the exigencies of public order and conducted in a way least intrusive to motorists. Valmonte versus De Villa. A checkpoint search may either be a mere routine inspection or it may involve an extensive search. For a mere routine inspection, the search is normally permissible when it is limited to a mere visual search. where the occupants are not subjected to a physical or body search. On the other hand, when the vehicle is stopped and subjected to an extensive search, it would be constitutionally permissible only if the officers conducting the search had the reasonable or probable cause to believe before the search that either the motorist is a lone offender or they will find the instrumentality or evidence pertaining to a crime in the vehicle to be searched. Cabales versus Court of Appeals. In Cabales, petitioner's vehicle was flagged down because the police officer on routine patrol became suspicious when they saw that the back of the vehicle was covered with cacahuate leaves. The fact that the vehicle looks suspicious because it is not common for such to be covered with cacahuate leaves does not constitute probable cause, as would justify the search without a warrant. On the other hand, in Now, it was held that the warrantless search was not bereft of probable cause. The Tarlac Police Intelligence Division had been conducting surveillance operations for 3 months in the area. The surveillance yielded the information that once a month, appellant and her co-accused transport drugs in big box. At 10 p.m. of October 1996, the police received a tip that two will be transporting drugs that night riding a tricycle. The two were intercepted 3 hours later, riding a tricycle and carrying a suspicious looking bag, which possibly contained the drugs in bulk. When they were asked who owned it and what its content was, both became uneasy. Under these circumstances, the warrantless search and seizure of appellant's bag was not illegal. In People versus Vinicario, when the appellants sped away after noticing the checkpoint and even after having flagged down by police officers, their suspicious and nervous gestures when interrogated on the contents of the backpack, which they passed to one another, the reply of Vicenario that he was a member of the Philippine Army, apparently in an attempt to dissuade the policemen from proceeding with the inspection, and the smell of marijuana that emanated from the package wrapped in paper. All this showed probable cause to justify a reasonable belief on the part of the law enforcers that the appellants were offenders of the law and the contents of the backpack were instruments used in or subject of the offense. Some cases. In People versus Balingan, the search of the luggage of a passenger in a bus after the officer had tailed the bus for 15 to 20 minutes was held valid because a tip received by the officers. This reiterates the ruling in People versus Lo Ho Ming received by the Lo Ho Ming, where the court gave approval to a warrantless search done on a taxi cab, which eventually yielded shabu because of a confidential report made by an informer. In Mustang Lumber versus Court of Appeals, the Supreme Court declared that the search of a moving vehicle is one of the doctrinally accepted exceptions to the rule that no search or seizure shall be made except by virtue of a warrant issued by a judge. The rationale for this exception, as explained by the court in the Sunshine versus Court of Appeals and reiterated in People versus Mariacos, is that before a warrant could be obtained, the place, things, and persons to be searched must be described to the satisfaction of the issuing judge, a requirement which borders on the impossible in the case of smuggling effected by the use of a moving vehicle that can transport contraband from one place to another with impunity. It is not practicable to secure a warrant because the vehicle can be quickly moved out of the locality or jurisdiction in which the warrant must be sought. In this case, the ruling in Aminuddin was held not applicable because the police authorities had already identified the shabu dealer, and even if they did not know the time he would show up in the vicinity and were uncertain what type of vehicle he would use, there was probable cause inasmuch as the same police officer had a previous encounter with the petitioner who was then able to evade arrest. However, in Bagalihog versus Fernandez, where respondent Rojas confiscated and impounded petitioner's vehicle or motorcycle, which was believed one of the vehicles used by the killers of Representative Moises Espinosa, the Supreme Court ruled that the confiscation without warrant was unlawful. The constitutional provision protects not only those who appear to be innocent but also those who appear to be guilty, but are nevertheless presumed innocent until the contrary is proved. The necessity for the immediate seizure of the motorcycle had not been established, neither can the vehicle be detained on the ground that it is a prohibited article. In Belmonte, the rationale for allowing the checkpoint was to enable the NCRRDC to pursue its mission of establishing effective territorial defense and maintaining peace and order for the benefits of the public. After all, as held in the resolution on the motion for reconsideration, the inspection is limited to a visual search, and neither the vehicle nor the occupants are subject to a search. Inspection of buildings and other premises for the enforcement of fire, sanitary, and building regulations. This is basically an exercise of the police power of the state and would not require a search warrant. This refers to a routine inspection which, however, must be conducted during reasonable hours, where prohibited articles are in plain view. Objects in the plain view of an officer who has the right to be in the position to have that view are subject to seizure and may be presented as evidence. The plain view doctrine is usually applied where the police officer is not searching for evidence against the accused, but nonetheless inadvertently comes upon an incriminating object. People versus Musa, and reiterated in Elenita Fajardo versus People, 2011. Requisites in People versus Musa, reiterated in People versus Aruta, and in People versus Sarap. The Supreme Court enumerated the elements of a valid seizure based on the plain view doctrine as follows: a prior valid intrusion based on the valid warrantless arrest, in which the police are legally presented in the pursuit of their official duties. The evidence was inadvertently discovered by the police who have the right to be where they are. The evidence must be immediately apparent, in plain view justified the seizure of the evidence without any further search. Thus in People versus Figuera, where while serving a warrant of arrest, police officers searched the house and found a pistol, a magazine, and 7 rounds of ammunition, the seizure of the firearm and ammunition was held lawful, because the objects seized were in plain view of the officer who had the right to be in the place where he was. In People versus Macalaba, the evidence clearly shows that on the basis of intelligence information that a carnap vehicle was driven by Abdul, who was also a suspect in a drug pushing, the members of CIDG of Laguna went around looking for the carnap car. They spotted the suspected carnap car, which was indeed driven by Abdul. While Abdul was fumbling about in his clutch bag for the registration papers of the car, the CIDG agents saw 4 transparent sachets of shabu. These sachets of shabu were therefore in plain view of the law enforcers. An object is in plain view if the object itself is plainly exposed to sight. Where the object seized is inside a closed package, the object is not in plain view, and therefore cannot be seized without a warrant. However, if the package proclaims its contents, whether by its distinctive configuration, its transparency, or if its contents are obvious to an observer, then the contents are in plain view and may be seized. Cabales versus Court of Appeals. If the package is such that an experienced observer could infer from its appearance that it contains prohibited articles, then the article is deemed in plain view. People versus Nuevas. In People versus Salingit, the peace officers entered the dwelling armed with a search warrant for the seizure of shabu and drug paraphernalia. In the course of the search, they presumably found the shabu first, and then came upon an article wrapped in newspaper which turned out to be marijuana. On the issue of whether the marijuana may be validly seized, the Supreme Court said once the valid portion of the search warrant has been executed, the plain view doctrine can no longer provide any basis for admitting the other items subsequently found. Note that the marijuana was wrapped in newspaper which was not transparent. In Musa, The Supreme Court said that the plain view doctrine may not be used to launch unbridled searches and indiscriminate seizures, nor to extend to a general exploratory search made solely to find evidence of defendant's guilt. Thus, in People versus Valdez, it was held that although the marijuana plants were found in an unfenced lot, they were not apparent. A police team had to be dispatched to search for and uproot the prohibited flora. Accordingly, the plain view doctrine could not be validly invoked to justify the seizure. In People versus Basudag, noting that the police authorities had ample time to secure a warrant, the seizure of the marijuana plants and the consequent arrest were held to be tainted with constitutional infirmity. The implied acquiescence of the appellant passive conformity given under intimidating circumstances. In People versus Compassion, where the peace officer had to enter the dwelling of the appellant in order to get to the backyard where they seized two marijuana plants, the Supreme Court said that the plain view doctrine cannot be invoked to justify the seizure. The four requisites enumerated in Musa had to be satisfied. The doctrine is not an exception to the warrant. It merely serves to supplement the prior justification, whether it be a warrant for another object, hot pursuit, search as an incident to lawful arrest, or some other legitimate reason for being present, unconnected with a search directed against the accused. It is a recognition of the fact that when executing police officers come across immediately incriminating evidence not covered by the warrant, they should not be required to close their eyes to it, regardless of whether it is evidence of a crime they are investigating or evidence of some other crime. It would be needless to require the police to obtain another warrant. United Laboratories versus EC. The immediately apparent test does not require an unduly high degree of certainty as to the incriminating character of evidence. It requires merely that the seizure be presumptively reasonable, assuming that there is probable cause to associate the property with criminal activity, that a nexus exists between the viewed object and criminal activity. Same case. In People versus Huang Zanhua, September 29, 2004, police officers, in implementing a warrant which authorized the search of the residence of the accused for methamphetamine hydrochloride, also seized credit cards, a passport, photographs, and other documents and papers. On the contention of the accused that the seizure of such items was illegal, the Supreme Court ruled that the seizure was legal because the articles were in plain view. Their seizure was authorized because of their close connection to the crime charge. The passport would show when and how often the accused had been in and out of the country. Her credit cards and passbook would show how much money she had amassed and how she acquired them. The pictures would show her relationship to the co-accused. The doctrine allows the seizure of personality even without a warrant as long as the area of search is within the immediate control of the arrested person and the object of the seizure is open to the eye. People versus de Guzman. Search and seizure under exigent and emergency circumstances. In People versus de Gracia, the raid of and the consequent seizure of firearms and ammunition in the Eurocar sales office at the height of the December 1989 coup d'etat was held valid, considering that the exigent and emergency situation obtaining. The military operatives had reasonable ground to believe that a crime was being committed, and they had no opportunity to apply for a search warrant from the courts because the latter were closed. Under such circumstances of urgency and exigency, a search warrant could be validly dispensed with. In Guenzon de Villa, the Supreme Court upheld as a valid exercise of the military powers of the President the conduct of an aerial target zoning or saturation drives. Note, in this case, the validity of the search was not directly questioned, raised in issue where the alleged abuses committed by the military personnel who conducted the saturation drives. In the absence of complainants and complaints against specific actors, no prohibition could be issued. However, the court temporarily restrained the alleged bangings of walls, kicking of doors, herding of half-naked men for examination of tattoo marks, the violation of residences, even if there are humble shanties of squatters, and other alleged acts which are shocking to the conscience. The Supreme Court remanded the case to the trial court for reception of evidence on the alleged abuses. Exclusionary rule. Evidence obtained in violation of Section 2, Article 3, shall be inadmissible for any purpose in any proceeding. Section 3, Number 2, Article 3, because of it is the fruit of the poisonous tree. Objections to the legality of the search warrant and to the admissibility of the evidence obtained thereby are deemed waived when not raised during the trial. De Maise versus Court of Appeals. In People versus Diaz, because of the failure of the accused to object to the admissibility of evidence obtained through an unlawful arrest and search, it was held that the accused were deemed to have waived their rights and the trial court did not err in admitting the evidence presented. However, even if the accused were illegally arrested, such arrest does not invest eyewitness accounts with constitutional infirmity as fruits of the poisonous tree. Thus, where the conviction could be secured on the strength of testimonial evidence given in open court, the illegality of the arrest cannot be invoked to reverse the conviction again. In People versus Salazar, even if the accused were illegally arrested, such arrest does not invest eyewitness accounts with constitutional infirmity as fruits of the poisonous tree. Thus, where the conviction could be secured on the strength of the testimonial evidence given in open court, the illegality of the arrest cannot be invoked to reverse the conviction. It does not necessarily follow that the property illegally seized will be returned immediately. It could remain in custodia legis, Ali versus Castro, Rowan versus Gonzalez. Thus, in People versus Estrada, even as the search warrant was declared illegal and the medicines or drugs seized were shown to be genuine, their return was not ordered because the producer, manufacturer, or seller did not have any permit or license to sell the same. But in Tambasin versus People, the money which was not indicated in the warrant and thus illegally seized was ordered returned. For the retention of the money, the approval of the court which issued the warrant is necessary. People versus Jesmundo. In like manner, only the court which issued the warrant may order its release. In Pita versus Court of Appeals, because the magazines subject of the search and seizure had already been destroyed, the court declined to grant affirmative relief. The property illegally seized may be used in evidence in the case filed against the officer or responsible for the illegal seizure. Privacy of communication and correspondence. Next upload, please.